If you're working with Chinese suppliers, manufacturers, or product developers, you've probably heard people say, just sign an NDA, and for many foreign companies that sounds like perfectly reasonable legal advice. After all, in the US, the UK, and many Western jurisdictions, a standard NDA is often the default tool for protecting confidential business information. But here's the problem. When you're dealing with Chinese suppliers, an NDA is often not enough. And relying on the wrong agreement can leave your products, your customer relationships, and your competitive advantage completely exposed. So today, let's break down the difference between an NDA and an NNN agreement, when to use each one, and which industries need NNN protection the most. Let's start with the basics. An NDA stands for Non-Disclosure Agreement. Its primary purpose is simple. It prevents the receiving party from disclosing your confidential information to third parties. That means if you share product specifications, prototypes, pricing structures, or technical processes, the supplier agrees not to pass that information to someone else. That sounds useful, and it is, but there's a major limitation. Most traditional NDAs only focus on disclosure. They usually do not prevent the supplier from using your information for their own commercial benefit, and they often do not stop the supplier from bypassing you and dealing directly with your customers or distributors. This is where an NNN agreement becomes essential. NN stands for non-disclosure, non-use, and non-circumvention. This means the supplier agrees not only to keep your information confidential, but also not to use it for themselves and not to go around you to access your market, customers, or commercial channels. That's a huge legal difference. Here's a practical example. Let's say you send a Chinese factory your custom product design. You also provide supplier contacts, pricing strategy, and target market information. Under a basic NDA, the factory may be prohibited from sharing that information externally. But unless your contract specifically restricts use and circumvention, they may still manufacture a similar product themselves. They may sell directly to your buyers. They may even approach your distributors and undercut your pricing. And technically, they may argue they never breached confidentiality. That's why foreign companies working with China often discover, too late, that their NDA was never real commercial protection. So when should you use an NDA? And when should you use an NNN? A traditional NDA may still work if you're having very early stage conversations. For example, preliminary investor discussions, general business exploration, or sharing non-sensitive information before formal negotiations. But once you are dealing with a Chinese manufacturer, factory, OEM, supplier, product developer, sourcing agent, or distributor, you usually need an NNN agreement. This is especially critical in industries where intellectual property, product design, or customer access creates competitive value. That includes consumer electronics, medical devices, biotechnology, pharmaceutical manufacturing, industrial equipment, automotive components, private label consumer goods, and increasingly software-enabled hardware products. These industries face high copying risk because Chinese suppliers often have direct manufacturing capability and immediate market access. Without NNN protection, your commercial leverage can disappear very quickly. And there's one more critical point. A real China-facing NNN agreement should usually be written in enforceable Chinese legal language, governed under Chinese law, and signed by the correct mainland Chinese legal entity. Without those elements, even a well-written agreement may be difficult to enforce in practice. The bottom line is simple. If you're relying on a Western NDA while working with Chinese suppliers, you may be protecting secrecy, but not your business. And in cross-border manufacturing, that distinction can cost millions. I'm Tom, and this is China Business Law with Tom.